Welcome to Brief On, the show where we break down complex legal concepts into easy-to-understand episodes. Today we're diving into something that affects all of us at some point: contracts. What are they? What happens if someone breaks one? And what remedies are available? Let's get started. A contract is essentially a legally binding agreement between two parties. It outlines terms and conditions that the courts have the power to enforce. Now, what happens when someone doesn't hold up their end of the bargain? That's what we call a breach of contract. A breach of contract occurs when one party fails to perform their obligations as specified. This could be anything from not completing a job, failing to pay on time, delivering substandard goods, or any act indicating they won't fulfill the agreement. When this happens, the non-breaching party can take legal action. For a court to consider a breach of contract claim, certain conditions must be met. 1. The contract must be valid. 2. The plaintiff must prove that the defendant violated the contract terms. 3. The plaintiff must have done everything possible to perform their part of the contract. 4. The plaintiff must have given the defendant fair notice of the breach.
Now, let's talk about remedies. When a contract is breached, several remedies can restore the rights of the non-breaching party. The most common remedy is damages. Damages are monetary compensations paid by the defaulting party to the aggrieved party. The primary goal is to put the injured party in the position they would have been in if the breach had not occurred. Let's break down the types of damages. First, we have ordinary or general damages. These are the direct results of the breach and are predictable when the contract is formed. For example, if a supplier fails to deliver goods, the buyer can claim the difference between the contract price and the market price. Second, special damages. These occur due to specific conditions known to both parties when the contract was made. For instance, if a tailor sends sewing machines to a fair, but they arrive late due to the railway's fault, the tailor can claim lost profits provided the railway was informed of the fair. Third, vindictive damages. Sometimes, monetary loss isn't the only consequence. Vindictive damages address non-monetary sufferings, like mental agony or loss of reputation. These are rare in contract law, but can apply in cases like breach of a marital contract or a bank refusing to honor a check. Fourth, we have nominal damages. These are awarded when a breach occurs, but no actual loss is proven. They recognize the breach and the injured party's right to compensation, even if it's a small amount. Fifth, liquidated damages and penalties are amounts stipulated in the contract for breach. While liquidated damages aim to fairly estimate the loss, penalties are meant to deter breaches. Unlike English law, Indian law doesn't distinguish between them but awards reasonable compensation up to the stated amount. Another important concept is the remoteness of damage, which determines what losses can be compensated. The landmark case Hadley v. Baxendale set the precedent. Damages must be a natural result of the breach or within the party's contemplation when the contract was made. Finally, how do we measure damages? The goal is to compensate the injured party as if the contract were performed. For instance, in a sales contract breach, damages are the difference between the contract price and market price at the time of breach. If a contract is partially performed before being breached, the aggrieved party can claim quantum meruit, meaning as much as is earned. This allows for fair compensation for the work done. In conclusion, contracts are vital in our daily transactions, and understanding what happens when they're breached can help protect our rights. Courts aim to ensure fairness and compensate the injured parties appropriately. Thanks for watching Brief On. Don't forget to like, subscribe, and hit the bell icon for more insightful videos. See you next time.